ago. I see Clark Palmer. How much does the fact that the public voted for district change weigh with the justices, and can that outweigh any possible legal issues? Excellent question, Clark. And it was actually Justice Russell's very first question of any justice in the argument. And I think he was just, everybody in the room knew the answer, but he asked, does the yes vote matter at all? He asked this of the counsel for Virginia, so the defendants. And Richard Hawkins, on behalf of the Solicitor General's Office of Virginia, conceded no, that the vote is irrelevant to the legal questions at issue. And, you know, putting my kind of commentator hat on, political commentator, not legal, I think the Democrats were probably counting on a much bigger margin and hoping that that would weigh heavily emotionally on the justices' minds as they considered these questions. But it was a very close vote, particularly when the yes side outspent the no side by 3 or 4 to 1. So even in persuasive effect, I don't think that vote is going to matter, Clark. Follow-up question from Joe Thomas. Attorney General Jones used the will of the voters in his statement last week. Yes, he did. And Joe asked, was the spending margin brought up or the turnout brought up as any sort of mandate? And no, the answer, no spending discussion or comments took place. The only discussion of this subject was the question and answer that I recited to you from Justice Russell and Richard Hawkins' answer to it, in which Attorney Hawkins acknowledged that the vote was irrelevant to the legal questions at issue. Brett Hall asked, why was the wording of the question not addressed? Great question. The answer is because that was addressed in the Tazewell case that was decided last week, that is coming up to the Virginia Supreme Court on appeal. The easy way to think of why the questions today occurred, they were what I would call the 2025 questions, the questions about first passage on Halloween of 2025. And the 2026 questions were decided by the Tazewell Circuit Court last week and are now coming up to the Supreme Court on appeal. I do not know that briefing schedule. I will post it as I learn it on my Twitter feed for folks. But the ballot question I actually put up on my Twitter feed also, so you can see it for yourself. It was ruled in violation of Virginia's plain English rule. Some states have a rule that, and when I say rule, I mean in law, a statute that requires fair and balanced language. Virginia doesn't have a fair and balanced statute, but we do have a plain English statute. And Judge Hurley ruled that the plain English statute was violated with the extreme misleading nature of the ballot language. So that was the ruling in the Circuit Court of Tazewell County, Brett, last week. That question, that is a statutory question, is coming up with the next appeal to the Virginia Supreme Court, along with the constitutional question of whether 90 days passed between second passage on January 16th and the submission of the question to the voters. And the issue there is early voting began on March 6th, which is less than 2 months after second passage, obviously not 90 days. But the other side will argue, well, April 21st was more than 90 days after second passage, and so that's what should count. So you'll be seeing that one come up. But that case will be mooted, and we will never hear it argued if the Supreme Court invalidates the referendum on either of the two constitutional questions from 2025 that were argued today, or on the statutory question that was argued today. I think the statutory question is very unlikely to be utilized to negate the referendum, but it is possible. Again, we didn't hear from 5 justices on that particular question. Justice Fulton weighed in on a different issue. So we'll see how that goes. And Clark asked how long before they would typically respond to what they heard today. So this is the fastest I've ever seen this court move. There was briefing so the referendum took place last Tuesday, and you'll recall in January and February, there was litigation on these questions in the circuit court, and they came up to the Virginia Supreme Court, and the Supreme Court held them and said, we're not going to consider these until after the vote. And that was not because they were ducking. That was based on over 110 years of precedent in Virginia law that says the vote is part of the legislative process. The direct analogy is the governor signing a bill. I'm looking at suing on the assault weapons ban that's been moving through the Virginia General Assembly, but that is on Governor Spanberger's desk. And I can't sue until she either signs it or allows it to become law, because she might veto it. And until that legislative process is over, a court will not hear my question, meaning will not entertain a lawsuit on that. So that's why they held the case, but they did set it up for contingent briefing. If the yes side won, they did. Briefs came in last Thursday, only 2 days after the referendum. An oral argument obviously was held this morning. They know the need for speed. They understand there are elections this year and that everybody needs to know what the maps are, whatever they may end up being. And the sooner, the better. I would, predictions are dangerous, but I would predict, Clark, that you're going to see a ruling in May, and I wouldn't be surprised to see one by mid-May nullifying the referendum. If I had to bet today, I would expect the Virginia Supreme Court to throw out the referendum because the process so brazenly didn't qualify with the requirements of the Virginia state constitution. Not seeing any more questions and not getting any directions from Melody. I'm gonna
Ken, just check a message I just sent you.
All right, we are watching a virtual press conference from former Attorney General Ken Cuccinelli.
Because we're also dual broadcasting this on Twitter from the election
Cuccinelli saying that he has never seen the court move so fast. The oral arguments that we heard this morning in Virginia State Supreme Court moving very fast to take up this case, and hearing arguments about the 2025 questions, and we'll recap that here in a second.
Let's see. So those of you on press, you can stay on here if you want. I am done here, but I'm going to use the Zoom channel to essentially redo this press conference to explain the case to folks on Twitter. Melody, do I understand that folks on Twitter only just now are starting to hear us?
All right, so we're going to dump out of that press conference here and go back and kill the audio here. So you just heard former Attorney General Ken Cuccinelli tell us that not only has the Virginia State Supreme Court acted the fastest he has ever seen it act in any case in this gerrymander here, he expects a decision by mid-May, and he fully expects the Virginia Supreme Court to overturn the gerrymander election we just had less than a week ago. So that is big news. Cuccinelli broke it down into say that Yep. Make sure I'm still here. I'm still here. Okay, so we're looking at the results here. I love this map. This is the map from last Tuesday. You see the purple vote is the no vote, the orange vote being the yes vote, highly concentrated vote in Northern Virginia, and then down in Chesapeake, Hampton Roads, and of course the Richmond metro area, Richmond City, Henrico, and Chesterfield counties there. Bringing in, this is Albemarle County here in the Charlottesville area. You have the cities, you have Stanton, Harrisonburg, Winchester, Roanoke here, all going for the yes vote. So, but at any rate, you see the vast difference between the state here. You have on the referendum. But going back to what Cuccinelli was saying, the arguments that we heard this morning in Scova were on the 2025 questions, and essentially what you had is you have the no vote, the conservatives, Republicans in this case, arguing, saying, listen, you waited until over 1 million people had already voted voted early during the 45-day early voting period for the November election, the November 4th general election. A 45-day period that Democrats pushed for back in 2020, a 45-day period that they say would allow more people a voice, give more people access to the polls, more people to be able to participate in the electoral process. They argued for that, giving Virginia the largest early voting window of any other state in the union. And today, we heard the people defending the gerrymander, the Democrats, say, well, yeah, but election day is still election day, and it doesn't really matter what we introduce after early voting begins. Doesn't really matter if you know what you're voting on. Doesn't really matter if you knew what we were going to do, whether or not we were going to hold a referendum or not on redistricting. If we introduce it later, which they did on Halloween, well into the voting period after over 1 million people had already voted, that doesn't matter because election day is still election day. So one has to wonder, can you have it both ways, right? Can you push for 45-day early voting period and then say, well, yeah, but the votes that cast, it doesn't really matter if you knew what you're voting for. It doesn't matter. Election day is still election day. And so now they're holding election day to account, whereas before they're wanting 45-day early voting period, which every voting registrar in Virginia who has to hold these elections, who has to actually work these elections, bring in staff to man their office, to have people walk in during the day, and then during the last 2 weekends leading up to election day to open early in-person voting locations, sometimes especially Northern Virginia, multiple early in-person voting locations. It's all very costly. And you can ask any voter registrar across the state that since the Democrats have put this 45-day early voting period in place, costs for elections have skyrocketed across the state. And taxpayers, you and me, end up footing the bill for this. And now for the yes vote, Attorney Jay Jones and his cohort that came in to argue this today, to say that those votes, don't really, it's not a big deal. It's not a big deal. It doesn't really matter if they know what they're voting on. Election day is still election day, and that's all that counts. And that was their argument this morning. And of course, you had the no vote saying, hey, listen, and they cited a Democrat who was one of the plaintiffs in this case, saying, hey, listen, if I knew this redistricting was going to be a thing, I would have voted differently. And also, if I had known that it was my delegate that brought this redistricting thing forward to the General Assembly that was eventually passed, I might have voted against that delegate because he was on the ballot in November. And I actually voted for the Independent Redistricting Commission back in 2020, as did 66% of the registered voters who participated in that election. Well over the majority of voters voted in for the Independent Redistricting Committee. And so that was one of the plaintiffs that we heard from this morning.